Some raise the question whether severability clauses are actually needed in California bills. Around the country and at the federal level, there's an ongoing debate among legislative lawyers whether a severability clause has to be included in legislation. If a bill contains a severability clause, then the matter of whether provisions contained in that bill are severable is readily resolved by a court. However, if a severability clause is not in place, then a judge must determine whether the entire measure is void or if any of the remaining provisions can remain in effect. Basically, a severability clause allows a valid provision of a bill to remain in effect even if one or more other provisions in that same bill are found to be invalid or unenforceable. So the severability clause is a statement basically of legislative intent that if a provision of a law is struck down by a court, then the unconstitutional or invalid provision or provisions don't invalidate the remaining provisions of the law. And so those valid provisions will remain in effect and be on the books. So what does a standard severability clause in California look like if you find one in a bill? It generally says the provisions of this bill are severable. If any provision of this bill or its application is held invalid, that invalidity shall not affect other provisions or applications that can be given effect without the invalid provision or application. Now, in California, our state courts generally follow a two-step analysis based upon a California Supreme Court decision. And the first step of it is relatively straightforward. The court simply looks to determine whether the enacting legislation contains a severability clause. And the presence of such a clause, according to the Supreme Court, is that it establishes a presumption in favor of severance. This was recently cited in California Redevelopment Association versus Mata Santos, a Cal Supreme Court decision in 2011, which was citing the language of a Cal Supreme Court in 1975 called Santa Barbara School District versus Superior Court. So as a result here, if a bill contains a severability clause, then the court usually follows the language of the severability clause. And these severability clauses can protect the remaining valid portions of a law. Or the clause can state that if any of the law's provisions are struck down, then the entire act has to fail and is invalid. On the other hand, if the bill does not contain a severability clause, then the court proceeds to the second step in the two-part analysis. And basically, in the second step, the court determines whether the invalid provision or provisions are called functionally separable from the remaining valid provisions. In other words, what the court says is that if a statute doesn't contain a severability clause, then the court has to find a portion or portions of the statute severable if that provision is grammatically, functionally, and volitionally separable. And again, this is coming from the Monsanto's case in a 1989 Cal Supreme Court in Cal Farm Insurance Company versus Deukmejian. So what's this second step exactly mean? Well, the California Supreme Court gave us guidance in the Cal Farm case, and they said grammatical separability considers whether the invalid portion of the statute can be stricken without affecting the wording or the coherence of what would remain in the statute. The High Court said that functional separability turns on whether the rest of the statute is complete in itself. And then finally, the volitional separability occurs when the statute would have been adopted even if the legislative body had foreseen the partial invalidation of the statute. So the California courts use this three-part test in the second prong to make a determination whether the invalid and valid provisions are functionally separable, and if so, then the remaining valid provisions can remain. But if these provisions are found not to be functionally separable, then the valid provisions cannot be severed from the rest of the bill, and the entire statute is declared invalid. So, in returning to the initial question posed, is a severability clause necessary in California bills? The answer is, as a general rule, bill drafters are generally instructed to only use a severability clause when there's a possibility of a statute being partially invalidated, and it may not be clear that the intention of the legislature is the bill be severed between its valid and invalid provisions. There are others in the drafting community who believe a severability clause is unnecessary for any legal purposes because many courts, including in California, have ruled regularly that regardless of the presence or the absence of a severability clause in a statute, the courts sever invalid provisions from an otherwise valid law whenever it's possible based upon judicial statutory interpretation principles. In other words, there are some legislative lawyers who argue that a severability clause ordinarily isn't really necessary because statutes and the common law make statutory provisions severable. And we see some of these severability provisions scattered throughout the California codes. Even the state constitution has a provision. It says that in Article 1, Section 31H, it says, any provision held invalid shall be severable from the remaining portions of the section. And there are California statutes that also have severability clauses. Government Code Section 9906 is actually titled Severability. So because some courts have given weight to the inclusion of a severability clause in specific statutes, we see a severability clause occasionally included in a California legislative bill, especially in some of the longer controversial bills, or of course, if a legislator client specifically requests the inclusion of one in his or her bill. But severability clauses are generally viewed as not being necessary in most pieces of legislation.